Good afternoon from ICJ Kenya House in Nairobi. My name is Abdul Nur Mohammed, Executive Director of ICJ Kenya.
And good afternoon from me. I'm Stella Ndirango, the head of the Africa program at Legal Action Worldwide, and glad to be co-hosting this webinar with ICJ Kenya as we try to advance the discussion on the next steps after the arrest of Félicien Kabuga.
On 16th May, Félicien Kabuga, one of the main financiers of the Rwandan Genocide, was arrested in Paris by French authorities. Kabuga had been living in France under a false identity and had evaded justice for 26 years. Félicien Kabuga is alleged to have incited and facilitated the commission of genocide in the Republic of Rwanda in 1994, when an estimated 800,000 Tutsis and moderate Hutus were massacred over a 100-day period. Kabuga is alleged to have played a significant role in the genocide by financing it and providing weapons that were used in the genocide, and also for establishing the notorious Radio Télévision Libre de Mille Collines, the RTLM, which incited people to kill the Tutsi population and issuing precursory statements against them. Created in the aftermath of the genocide by the United Nations Security Council in November 1994 was the International Criminal Tribunal for Rwanda, the ICTR, which was located in Arusha. In 1997, the ICTR indicted Kabuga on 7 counts of genocide, all in relation to the crimes that were committed in the 1994 genocide. Following the indictment, international, regional, and national efforts were intensified in his search, with the ICTR filing an operational indictment on April 14, 2011, and collecting statements against him. After the ICTR was closed, Kabuga's file was handed over to the prosecutor of the International Residual Mechanism for Criminal Tribunals, popularly known as the mechanism. His arrest last month in Paris by the French authorities was a result of a joint investigation by the French authorities and the mechanism's office of the prosecutor. On 20th May last month, Kabuga was taken before the French court, where he denied all charges labeled against him. The French court has now ordered the transfer of Kabuga to the United Nations Tribunal for trial.
Now, I take this opportunity to introduce our panel to you this afternoon. We have a panel of 3. And to start us off will be Wilfred Nderitu, who is an advocate of the High Court of Kenya, a former lead counsel at the UN ICTR and the UN IRMICT, which is the mechanism. And he's also been counsel to victims at the ICC in the Kenya cases. We will also hear today from Chantal Umuhoza, who is a Rwandan feminist activist and survivor of the 1994 genocide. She's the founder and executive director of a civil society organization called Spectra that is based in Rwanda. She's also a member of the African Union affiliated network of African women in conflict, prevention, and mediation. Alan Gary will be our third speaker, and he's a senior researcher and project manager under the program for the complex threats in Africa at the Institute of Security Studies, and he's based in South Africa. Welcome, panelists. And to start us off in this discussion, we will go to Chantal, who will ask the first question. Chantal, following Kabuga's arrest, we have seen genocide survivors taking to different platforms to react to the arrest. Valerie Mukabire, a leader of Avega, which is a group of widows who survived the genocide, is reported to have said this, that every genocide survivor is happy that Kabuga has been arrested. Everyone has been waiting for this news because he was on top of the list of suspects. It is a good thing and that he is going to face justice. Chantal, what is the significance of this arrest to you and to other victims and survivors of the genocide?
Thank you so much. Obviously, this was news that was welcomed by genocide survivors to know that finally it has taken long years, but finally he's going to be brought to justice. However, it has also opened the wounds. It has also raised questions and concerns about how long does it take for people who commit this kind of crimes to be brought to justice. It also brings up questions around the breakdown of multilateralism, basically the working together and cooperation of countries, knowing that he's lived in various countries, he has thrived, he has conducted business as usual for all these years. And so, yes, we welcome the news, but at the same time, we are heartened to see that we have a system, which is the international justice system, that is not operational or that is not working as we would like it to work, as like any genocide survivor would like it to work. Seeing that many countries can be supportive of him instead of working together with Rwanda to have him brought to justice is definitely heartbreaking for all the genocide survivors, myself including. And I'm speaking as a genocide survivor. I was 8 years during the genocide. And so 26 years later, for me, I do not even see or consider this as something that I can celebrate, because for me, justice has meant that the government has invested in the people, ensuring that they can be able to relieve, to recover from what happened to them, ensuring they can, have hope again in this country. And that's something that I call that has been my justice, to be able to restore my and have hope again. But this international justice system and how it has worked, and specifically for the case of Kabuga, for me, it's something that raises questions and questions that need answers about how do we make this better.
Thank you, Chantal.
Wilfred, you've been a defense counsel before the ICTR. Now, the ICTR has delivered, by the time of its last appeal judgment in December 2015, it had been on for 20 years. The trial chamber had rendered 55 first instance judgments that was involving 75 individuals. The appeals chamber, in turn, had rendered 47 final judgments in respect of 61 persons. And the remaining cases have now been handed over to the mechanism. One of the criticisms is how long cases took before the ICTR. In your opinion, what are some of the best practices and solutions to these challenges, to how long it takes to prosecute cases in an international court like the ICTR and now the mechanism? And what will be the best next steps following the arrest of Kabuga and his arraignment in court? Wilfred.
Thank you, Abdul. Now, I think I would want to start by contextualizing the reason why it takes an awfully long time to try cases at the international level. The first thing we need to recall is that it takes a lot of investigations, and it is not always the case that investigations or reports that come in from people that are interviewed will be straight on point with regard to the offenses that need to be charged. So there is a lot of money that needs to be spent at that level. But so by the time that a matter is taken before an international criminal tribunal, or before the ICC for that matter, being the International Criminal Court, it will have taken at least a couple of years. Now, this is unlike the kind of cases that we try in the domestic systems, which will ordinarily just be dealing with one victim or several victims. But here we are talking about cases that relate to lots and lots of victims. Now, on top of that, we need to remember that once the cases are when they're in the process of being investigated, we are dealing with a system that does not even have a local enforcement mechanism in terms of ensuring that the investigations go the way they should. Now, what will then happen is that in a typical scenario, you will have people that will come into a country where they need to understand its cultural context, will need to understand the language of the people, and then will need to rely on the goodwill of the country that is being investigated, or where we have suspects that are going to be investigated. And that is not a very, very easy thing. Now, what we need to do is we need to, first of all, ensure that there is depoliticization of tribunals and the international criminal justice as a whole, where we do not end up spending, sorry, let me take that again. We need to ensure that the international criminal justice is not politicized whatsoever, because when you politicize the international criminal justice, then it means that people will lose faith. And the way to ensure that it is more effective is, first of all, to ensure that at the domestic level, we internalize international criminal justice. We need to ensure also that we empower the regional systems that we may call to play.
Thank you. Alan, let's turn to you. Kabuga's arrest provides us with an opportunity to reflect on a bit more on how international criminal justice can be more effective for victims and survivors specifically, while also respecting the rights of the accused. What insights might you have that you can share with us today based on your research on other similar proceedings that would be beneficial if observed for the Kabuga trial?
Thank you. Thank you very much, Stella, for the question, and just for the opportunity also just to share some of my insights. I think I will turn to the question around the significance of this arrest at this particular time. It happens during Kwibuka, the annual commemoration of the 100 days of the genocide against the Tutsi. It's significant because the memory of the genocide against the Tutsi in Rwanda is fading. And there are a number of reasons for this. Of course, it's been 26 years. The international community is plagued with numerous other priorities and concerns. And despite the good work that is being done around memorialization, there are some sinister revisionist elements and various other activities that put this particular episode in history in the back burner. But in the wake of Kabuga's arrest, the focus has been on where he has been hiding, who protected him over the past 26 years, where should he be tried? And these are key concerns, including accountability for all those people, all those entities beyond just natural persons that aided this fugitive for justice for so long. But perhaps we should also be asking how victims and survivors of the genocide can best be served in the coming months. A trial will contribute to the collective narrative of history, memory, truth, but what about reparations for survivors? The question of reparations, it's a major gap in the delivery of justice to survivors in Rwanda, but just generally for victims of international crimes, as I have been studying this particular topic. But at this particular time, it should take center stage. As the international community grapples the question of where should Kabuga be tried, an opportunity presents itself for us to place reparations for the survivors of the genocide at the very center of this debate. Reparations are important because They acknowledge the pain and the suffering that the victims and the survivors have endured, but it also assists victims to move past their victimhood. Now, we know that the ICTR was purely retributive in nature. It scarcely turned to reparation. The statute that created the ICTR addressed restitution in its provision, but it did not specifically make any pronouncements. In almost the 21-year existence of that court, there was not a single order for restitution that was made by its judges to any of the survivors of the genocide. There was some form of assistance that was given by the Victims and Witnesses Protection Unit to survivors who appeared in the court as witnesses, but survivors were largely seen as objects of the proceedings more than the subjects of the proceedings. The situation is worse with the residual mechanism, the IRMCT. It's not as easy to flow as ICTR, so we'll just call it the mechanism. There is no reference for reparation in any form. And Kabuga's trial at the mechanism should be more significant for survivors of the genocide than just a mere anecdotal link to satisfaction, which in any case remains unempirically linked or demonstrated for purposes of Rwandan survivors. So I think one of the big things that we need to rethink at this point in time as we turn to the trial is the question of reparations. It's a bigger question. It requires a lot of discussion in terms of where the financing would come from, the technical and the political support, but those are issues that we can certainly discuss in this discussion.
At this point, I'd like to remind our panelists to please send in your questions to the panelists. You can send them through our chat, and later on we will open our telephone lines. Please, let's take this opportunity to engage with them on this webinar. My question is to Chantal. Chantal, having lived through the genocide, what are your hopes from this arrest and from the impending trial? Will it bring closure to you and to those who experienced the genocide?
Thank you so much. And like I said before at the beginning, this, for me personally, does not bring about any closure. As we speak, after 26 years, I have not been able to find where my mom and my two sisters, then 10 years old and 2 years old, were killed and buried. I just know they died and were killed in the genocide, but haven't been able to find them and where they are, and haven't been able to put them to rest. So there is no closure with this arrest, but what I'm hopeful for is that the process might be able to bring out some information because Rwanda as a whole, not just genocide survivors, we are still going through learning and recovery. And so any information that we get from this process, especially being that Kabuga was the mastermind, was funding of the genocide in different ways. And so the information he might have about the genocide in general, but also the planning and the execution of the genocide in collaboration with some international states or actors, be it states or other organizations. So and so as we know, during 1994, the international community gave up on Rwanda. There was no much help going on. And so even though we also know and there are many survivors that have continuously highlighted the role of the international community, different actors in the genocide. And so my hope is that we can also get information on these kind of aspects, not only in the role of Kabuga, but also other people that might have been part of this whole planning of a genocide. And so my hope is to get that kind of information for the purpose of not just me, but we as a country, Rwanda, to be able to learn from that. We are committed on what we mean by this should never happen again. And so any information or any other learning we can get from this process definitely will strengthen the efforts that are already there in the country. And that's my only hope.
Chantal. Alan, let me just come back to you, given Chantal's response to that last question. And I want to just ask, with respect to the fact that Kabuga is known as the main financier to the genocide, and reality being that he has actually evaded justice this long because of also the finances that he had. And the issue that you raise around issues of restitution and reparations, do you think then this is an opportunity to start a conversation on the possibility of ensuring that any remaining finances from Kabuga should actually be frozen, traced, frozen, and also just ensure that these go towards the providing some form of reparation for the genocide survivors who, as we hear from Chantal, remain, this will not definitely offer them any form of closure, but we could help at least with trying to alleviate some of the suffering that they have endured for over 26 years.
Yeah, it's a very good question, because what it does is it brings to the fore some of the challenges that the whole field of reparation for victim is experiencing. And as I said towards the end of my response to the first question that you asked, reparation needs financial, technical, and political support. So we know from the current mechanisms that are in existence in Africa, we know the trust fund for Hissène Habre's crimes. It's struggling in terms of the financial component to it. There isn't money that has been put to it that would assist the Chadian victims following the conviction of the former president Hissène Habre. It's a similar question with the Trust Fund for Victims at the ICC, the question of funding. It is always in need of funding, and had those finances been available, I think that the reach of reparations would have been much, much wider. We also saw at the International Criminal Court the question around seizing assets of accused persons. And I think this is where your question comes in. It was quite unfortunate that that the assets of the former accused person, now no longer accused, Jean-Pierre Bemba, in the situation in the DRC, related, some of his assets were frozen, were seized in the hope that should he be found guilty, which he was not, then those assets would have been available to the victims in the case against him. So what happened in 2001, I believe, the ICTR did freeze some assets belonging to Kabuga, and they were in various European countries, and this is quite a very interesting process of how the court works. The ICTR was a creature of the Security Council, so by virtue of the fact that Article 25 of the UN Charter obliges all member states of the UN to cooperate with it, it was easier then for the cooperation regime between states and the ICTR to have happened. So some of his assets were frozen, not all, certainly. And it would be a really good question for us to turn to at this point in time. Can we find where those assets are? Could they be forfeited? Could they be seized at this point? Of course, he remains innocent until proven guilty, and this is why the trial is important. But in the event that he is found guilty, we have seen in previous tribunals that and at the International Criminal Court, that on the basis of a guilt of an accused person, then reparations could follow then to the victims. And that could be one avenue of getting some reparations for the survivors of the genocide against the Tutsi in Rwanda, following from the end of the case against Kabuga. But there are other processes as well that could contribute to supporting the financial burden of reparations. The US State Department had issued under its Rewards for Justice program a bounty, quite a handsome amount of $5 million that anybody that would have come forward with information as to where Félicien Kabuga was hiding since he was indicted by the ICTR would then receive this amount of money. Now, how he was arrested on the 16th of May, as Abdul began this webinar by explaining to us, it was because of the cooperation between the Office of the Prosecutor of the mechanism as well as the French authorities. None of those require the rewards for justice money. That money could be used to establish a reparations fund, a trust, whatever name you want to give it, for the survivors of the genocide against the Tutsis in Rwanda.
Thank you. Wilfred, coming back to you, while the arrest of Kabuga has been lauded as a huge gain in the international justice realm, a lot of questions have also emerged on whether Kabuga should be prosecuted by the Rwanda authorities or the mechanism. From the ICTR to the ICC, the prosecution of these cases in jurisdictions other than where the crimes occurred has exposed a lot of challenges, evidentiary challenges, because of the complexities that surround investigations and prosecution that happen, of international crimes that happen remotely. And in the current instance, Rwanda has also established and proved its capacity to try genocide cases, including some that were transferred by the ICTR as it was closing down and scaling down operations. In your opinion, what would be the appropriate forum for the prosecution of Félicien Kabuga?
Thank you, Stella. I think I would want to start by eliminating those that may not be suitable or available fora. And the first that I would eliminate is the International Criminal Court, the ICC, for the simple reason that when the genocide in Rwanda happened in 1994, the ICC had not even been established. And therefore, there would not be a retroactive effect available for Kabuga to be tried there. There has been, there have been arguments that he could be tried in France, for example, and of course in Rwanda. And with regard to that, I would want to say that the first thing is that the principle in criminal law is that crimes should be tried as closest as possible to where they're alleged to have been committed. And for that simple reason, France, again, may not be a proper forum because people who survived the genocide, for example, would not be able to follow on what is happening in that court. That then leaves us with two important institutions. One, the Rwandan courts, and two, the MICT. And the question is, what about Rwanda, given that this is perhaps as close as possible to where the offenses occurred, or the crimes? Actually, sometimes I would rather use the word crime because that has more impact than just offense. Now, Rwanda does have the capacity to try crimes, including crimes against humanity. But again, you will understand that Rwanda itself happens to be where there was a lot of polarization that led to the genocide. Polarization between one ethnic group and another ethnic group. And therefore, for that reason, it may be seen in the eyes of some that justice might not be, might be done, but not be seen to be done. And therefore, it is a forum that would be better avoided. Perhaps, if not for anything else, given the very, very high profile of Félicien Kabuga and his assumed role. I'm saying assumed because I want to give him the benefit of, I want to presume him innocent until he's proved guilty. He is presumed to be the one who largely funded the genocide. And the case may very well be that by trying him in Rwanda, a lot of other undesirable consequences may be visited upon the country or upon the inhabitants of the country. So it perhaps is better to have a forum that is neutral, and therefore we would need to balance between neutrality between proximity and all the other factors. And that is where MICT, being in Arusha, which is right next door to Rwanda, might be an appropriate forum.
Thanks, Wilfred. My next question is to Alan. Alan, a lot has happened since the establishment of the ICTR for accountability of great crimes, both on the African continent and in the world. There are numerous challenges in prosecuting any leader for genocide or crimes against humanity, as we've seen in Rwanda, in Sierra Leone, or in any of the situations before the ICC. But the one thing that is evidently clear is that we can never get successful prosecutions if states don't cooperate with each other and with the court or tribunal that is prosecuting. Isenhabra's case is one in point of successful cooperation between states and with the tribunal. What, in your opinion, are the main challenges on cooperation facing us as Africans in getting accountability for atrocity crimes? And how can the relationship between national judicial bodies and international justice mechanisms be strengthened? Alan.
Thank you, Abdul. It's a very seminal question in international criminal justice. How do we ensure the cooperation of states with the mechanisms that have been established by the states themselves to bring accountability for crimes? We need to perhaps make the distinction between the mechanism, the residual mechanism, as well as the International Criminal Court and other tribunals. The mechanism is a creature of the Security Council, and by virtue of the fact that it's Article 25 of the Charter of the UN obliges member states to comply with the decisions of the Security Council made under Chapter 7. And this is a Chapter 7 decision that created the mechanism, so states are required to cooperate with the residual mechanism. It doesn't mean, however, that we've had full cooperation of states. I recall that during the lifetime of the ICTR, some states which were alleged to have been harboring Kabuga were not in any way cooperative with the court. As to the sanctions thereafter for such states for lack of cooperation, is a big question, and we started seeing the challenges of enforcing cooperation obligations on states from as far back as the ICTR. These carry on through to the ICC, which is a creature not created by the Security Council or the United Nations by states, but by states themselves, and that court then requires only states parties to the Rome Statute to cooperate with it, with just the one exception that where a Security Council referral of a case, such as in the situations in Darfur and Libya, then those two particular countries, Sudan and Libya, are required to cooperate with the ICC. And so third states are not required to cooperate with the ICC specifically, from a general point of view. So the challenges with respect to cooperation are enforceability of those cooperation regimes themselves. With the challenges that we experienced with the ICTR and some states not being very cooperative with the court despite requests being made and intelligence going ahead and information being presented that some fugitives might be in certain countries. We expected to see the Security Council of the United Nations then step in and make an intervention to enforce the decision around non-cooperation. I mean, a decision of non-cooperation ought to have been made. I think we are seeing these decisions of non-cooperation now becoming a key feature at the International Criminal Court. So there's been some development, at least those decisions are being made. but enforceability of the cooperation regime remains the largest, the biggest challenge towards cooperation between tribunals and states themselves. That's not to say that there has not been cooperation. In fact, you will hear a lot of the registries in these international courts, tribunals, give you some very good examples of the forms of cooperation that exist between not just states, but also other non-state actors with a tribunal towards the goal of accountability. Oh, and the last question on the relationship then with national and international mechanisms, and I'll just center it perhaps around this, the arrest and subsequent trial of Kabuga. The ICTR was very clear that of the 8 at the time fugitives from justice, 3 of them, one of them being Félicien Kabuga, would be tried at the residual mechanism. So it almost seems to be a foregone conclusion that that is the mechanism, that is the forum that he will be tried. And I fully associate with every point that Wilfred has just spoken about in that regard. But I think one of the biggest questions in terms of the relationship then between national mechanisms and international tribunals and national judicial systems, national criminal justice systems, and international tribunals is how they could better work together. And here is a good example of that should actually take place. I agree that there are sensitivities around having a personality such as Kabuga tried in Rwanda, but nothing stops a discussion being made. I mean, it remains, the situation remains to be seen as to whether Rwanda will actually request for Kabuga's referral to its national jurisdiction. But nevertheless, we know that Rwanda's judicial system has significantly improved since it was decimated in the genocide in '94. But some of those security concerns might still persist today, and some key features such as witness protection would be quite important. But there is an opportunity to see how this could better work. I think we're seeing with the Kosovo tribunals, the hybrid tribunals, we are seeing some form of relationship between the international tribunals and the national mechanisms. And I think it's a relationship that would really benefit greatly both the mechanism as well as the Rwandan legal system and its people. I read an article very recently by the director of the Center for Conflict Management, Dr. Alphonse Molefu, speaking, opining about this whole issue. And he put it very well that the mere legality of where the trial will take place will not resolve that age-old question that we see in international criminal justice, where it has failed to connect to the real beneficiaries of the work. And I think this was quite put well by previous speakers as well. Abdul, you also said this at the beginning. The failure to attend to national and victims' interests is quite a big one. And here is an opportunity that the mechanism should take to be better than the ICTR, which is far removed from the very people that it was meant to be bringing justice for. So there are good reasons for both Rwanda and the mechanism to positively collaborate. Rwanda has an interest in seeing the mechanism successful in completing its work, especially because there are still some more fugitives who are out there, although information is emerging that some have since deceased, but there remains at least one that needs to be tried by the mechanism. And all of them, on all these processes are gearing towards the same goal, which is to bring justice for all the victims. The one aspect that has been forgotten, which I mentioned, was the question of reparation, but also the question of participation of the survivors themselves in these processes. And we didn't see that at the ICTR We don't see it also with the residual mechanism statute, that there would be an opportunity for victims to participate. And perhaps as we rethink, justice in this particular case, as we try Kabuga, there could be an opportunity to bring in the survivors to be more than just objects of the criminal proceedings, but subjects, and to participate. And through that process, perhaps also bring meaningful reparations to them.
Thank you, Alan. I think that last point is extremely important, the participation of the survivors in the trial. We now have a caller. Don Dare is calling in from Arusha. Don, are you on the line?
Yes, I am. I don't know if you can hear me.
Yes, we can, Don. Go ahead.
Thank you very much. I actually had two brief questions, one for Chantal and one for Wilfred. Dear Chantal, as a survivor of the genocide who wants to see justice not only done, but be seen to be done, what demands would you make of the mechanism in terms of your right, you're being allowed to participate in the impending trial? Would you like to participate, and how would you like to participate? And for Wilfred, as you know, in respect of Félicien Kabuga, Augustine Bizimana, that I can remember of, and others, the ICTR held special depositions, proceedings for preservation of evidence by way of special deposition in case of a future trial. How can this be used now that Mr. Kabuga has been found? And does this strengthen the argument for letting the mechanism have a role in the trial of Mr. Kabuga? Thank you.
Thank you, Don. Chantal, do you want to take the first question from Don?
Yeah, sure. So that's a good question. And like, I would assume like any genocide survivor would love to see the case and the process happening as close to home as possible. It always, I'm not an expert on issues around which forum these kind of crimes have to be tried on and which one fits or not. But it still feels wrong when these kind of crimes are committed, and then the process of the trial process is way detached or does not happen to where the crimes were committed. Even though, as you know, in the past cases, there have been attempts and support for survivors to be part of the processes, but as long as these processes happen where the crime was not committed and in an environment that may not always be as conducive for these survivors to be in this space, it's more hectic for them to be in these processes. It's more difficult. So that question also really strongly relates about the issues around the national justice systems in Rwanda that we have. And I think, obviously, this is just me speaking from my own perspective and not as at the country level, but a lot has changed in the country. The systems have been strengthened. There's a lot that has changed. There have been cases that have been tried in Rwanda. And as long as I can understand the concerns around we cannot trust fully about how the process is going to be, there is polarization or not, those kind of claims. But still, even my wish would be for the process to be tried in Rwanda, but in support and in working collaborations with other international justice mechanisms and processes to support, be there as maybe observers or support or guiding, but at least in the process, I also would see this, if it was done in Rwanda, it would also be a way to strengthen the mechanisms here. Because the whole argument that is always made that we cannot do it here because the systems are not as strong, we don't have ABCD, that also means the more we take these processes away from where they happen, it also leaves that gap that these states cannot have the opportunity to strengthen their processes and systems. So that would be my wish. Obviously, I know there's a lot that has to be going into that, but that would be how I would wish that, this kind of case can be tried where it was committed. And I'm saying this mostly because when you refer to the case of Kabuga, it's not so much about him against certain individuals. The crimes he committed about planning and funding the genocide are beyond individuals, single individuals. These are crimes on the state, on the whole population, on the people of Rwanda. And therefore, it's not so much about some individuals that have to participate in the process, but it's about how Rwandans as a whole can understand the process and learn from this whole process as a whole. And that definitely would be my wish. But yeah, when it comes to the international justice mechanism, yeah, there might be a lot that I don't understand at this point, but as a survivor, that's what I would wish. And in the process of advocating and doing things that we have to do to improve the international justice systems and processes, this needs to be taken into consideration. You know, trying cases, but in the process also strengthen national systems so that they can be able to try their own cases in a way that is desired. Thank you.
Thanks, Chantal. There was a second question from Don to Wilfred. Wilfred?
Yes, thank you, Abdul. I think I would want to say that the Rule 71 provision is very, very important and would come to play in a situation such as this. You will recall that this provision is supposed to be used where a person, where, for example, we have a fugitive, somebody who has escaped justice, and as at the time that the ICTR was closing, or was where the closure was imminent, it was not possible to take proceedings against such a person because of the fact that he had escaped justice. Or in situations where, for example, a suspect may have died. That is where the provisions of Rule 71 bis would come in. I see that this would actually be a proper situation for the application of Rule 71 bis, or if I may correct that into this being a proper situation where evidence that has been collected through depositions made under Rule 71 bis would be used by the MICT, or if before the MICT, the question then is brought in, perhaps by the government of Rwanda as to whether Félicien Kabuga should stand trial in Rwanda, then that is evidence that should become available. And I would say that the use of such evidence would strengthen the role of MICT, and particularly at a time like this, where the MICT has been largely seen as a mechanism that has been dealing with cases that relate to false depositions or the giving of false testimony. I think this would really be one way of showcasing the capacity of MICT.
We have another caller. Charles, I believe you can call in now. Are you there? Charles? Unmute. Kindly unmute, Charles.
Can you hear me?
Yes, we can hear you. Yes, please go ahead.
Good afternoon. Charles Adiogun Phillips, former lead counsel, prosecutor, ICTR. I just want to pass some comments in connection with Wilfred's statement and the issue as to whether or not possibilities do arise or will arise for Kabuga to be tried elsewhere but the ICTR. That is not the case. The ICTR does have primacy over all matters charged by that court. It is not in any doubt that Kabuga will have to be tried by the MIT, which is the subsidiary organization that took over from the ICTR. So that is not in any question. However, the tribunal may itself decide that the venue, so whilst the forum itself is not in question, the location of the trial can be moved for various reasons from the seat of the tribunal or the MIT in Arusha to maybe, for example, Rwanda or The Hague, depending on the circumstances that present themselves. But the forum has to be the ICTR. That is the first point, very big. The second point, I think the most challenging thing about this case is based on his age, his advanced age, his 80+ years, there has to be efforts made to have the most efficient trial possible. We don't want to end up in another Milosevic situation where after so many years, Kabuga is apprehended and then he dies during his trial. So what that means in practical terms is that efforts have to be made to have a realistic trial strategy. Minimal charges, minimal counts. We want to get in there. We want to get out as quickly as possible with the maximum result. And there is no scope to overbroaden the scope of his trial and with the result of ending up, unfortunately, as the ICTY did in the Milosevic case. Those are my contributions.
There are also some questions that we have received which are very relevant to this discussion. Some of them have just been typed out, so I'll just read out one of them, and hopefully, Alan, I would direct this to you because you're the one who spoke about the possibilities around utilizing the resources that are out there that belong to accused persons to ensure that there's some form of reparation. So Gitonga Muranga actually wrote in to ask that there's actually a case before the High Court in Kenya where some of Kabuga's property was being requested to be frozen, and in which his wife, allegedly, who is now deceased, has laid a claim. Gitonga asks, how can we move forward with this case in line with the current events? Alan, could you please take that question?
Yes, I'll take that question. It's a very interesting one. I did hear about that case of I think it was a property in Nairobi that belonged to Kabuga, allegedly belongs to him, and there were claims by his wife. I didn't know that actually it had not proceeded, which is unfortunate. But I think those are processes that really should be completed at this point in time. And here is where we see aspects of cooperation as well of states. I mean, here is an opportunity where the MICT, the residual mechanism, could take advantage of ongoing court cases, processes within states, and see them to completion and provide more information. I'm not sure what reasons there are that the court has not made the decision that it needed to make, and the High Court in Nairobi. I'm not sure what the reasons are for that, but if it is for want of more information, this is a very good opportunity to get cooperation between the residual mechanism and the Kenyan government. I believe also that I read a question that possibly came from Don about, and it's also related to this financial aspect of reparation, and it's a very good question. Who should we put the burden of reparation? Under international law, it is the state itself that has the obligation to repair victims of gross human rights violations, serious crime, international humanitarian law violations. In this particular instance, I think it would be fair to place the burden on creating a reparative regime to the Security Council. It created the ICTR, it created the residual mechanism. It has every responsibility to do it. And, I hear arguments around, that was a time when we had yet moved in victimological studies on how criminal tribunals would provide either the right to participate in proceedings as well as the right to reparations. But I respectfully disagree with that view. The negotiations at the ICC for an ICC were already advanced at the point that the ICTR was established. In fact, the statute had already been adopted in '98. So those thinkings were there, and there was a missed opportunity there by the Security Council to ensure that victims could participate, as well as the right to reparations. So I believe that the UN should take full responsibility to institute, or at least provide a mechanism, both in financial terms, in political support terms, in technical capacity as well, of creating a reparations and participatory regime for the survivors of the genocide against the Tutsi. But more importantly is that those processes, this is also a good opportunity to correct some of the wrongs in reparations and participatory regimes, that we need to have the survivors themselves plan for the reparations processes. They need to implement them. And we also need to have some way of monitoring and evaluating that is led by Rwandan survivors themselves. I think it's really wrong that we have survivors who have taken up a lot of professions and have skilled themselves ever since '94 and are able to actually do this. It's a same contestation around whether Rwanda can try Kabuga. Yes, while it is indeed a foregone conclusion that the MICT will have jurisdiction over it, it precludes the opportunity for allowing the survivors themselves to be involved in every aspect, not just the reparative, but also the retributive aspects. And I think that this is a time for us to reflect on this as well and to push hard. So what should we be agitating for at the AU level? I believe perhaps at the AU we should be focusing more on seeing how Hissène Habre's victims can get reparations through the already established fund and statute for related to that situation. And that's where efforts perhaps should be going in, maybe broadening it to be able to cover many other African situations and processes. And that's where the advocacy should be led. But for now, because we are dealing with this issue related to the survivors of the genocide against the Tutsi, how do we involve them to participate in the proceeding against Kabuga? How do we involve them in a reparations program that would then be tied to this case, but also separate from this case, alive to the fact, I think it was Charles who mentioned the complexities around his age. We have to also decouple the reparations process from the trial process itself, so that then survivors would get that meaningful reparations outside of a legal process that would lead to either a conviction or an acquittal.
Thanks, Alan. And the issue on reparations and participation on victims seems to be a very important one. And at this point, I want to thank the participants who are joined in today, particularly the survivors of the genocide. And Albert Kasaki, who is a survivor, has sent in a comment, and he says, as a survivor, the ultimate way survivors want to participate is being able to file reparation claims, as opposed to being just witnesses for the prosecution. So thank you, Albert. That is an important comment. It's very relevant to what we're hearing in what Alan has been saying. But still on that point, Alan, there's a question that Don had sent, and he says, thank you for some very good ideas on reparations. Should the UN have any obligations to finance reparations at all? Can we engage some advocacy around it? Should the African Union, the success of the OAU that was existent during the Rwandan genocide, have those obligations?
Yeah, I'd sort of started answering that question or those questions, and I do think that the Security Council has an obligation to provide for reparations or to establish or kickstart the process. It will need more than just you know, the name of a fund, but it will need resources. It will need, and resources can come financially, it can come politically, it will need the technical assistance. So yes, a very simple answer to that is the Security Council should have an obligation to correct the error that it made in when it created the ICTR, and including the ICTY, in not providing for reparations to victims. And I think it would go then to Albert's point that unless there is a process, because as it is right now, the ICTR and its successor, the residual mechanism, the statutes that created them did not mention reparation at all. It's only the ICTR statute that mentioned restitution, which is a form of reparation. Never made any decision around restitution. The residual mechanism has no mention whatsoever for reparation. So there needs to be a correction there. The Security Council, because it is a creating body, should actually make a change to the statute or make some supplementary a decision that would then support a reparations framework. What we have learned from our studies in reparations for victims is it is an afterthought. And even my call for a Security Council action on this is a testament to this afterthought, that we don't think about that aspect of victims' needs. And so we don't provide for it. So we would need a concerted effort going forward for all mechanisms that are created that would put victims at the very center of their creation. So they would be involved in participating in the proceedings, they would be involved in some process of reparation. But the reparation should not be tied, should not solely be tied to the guilt of the accused, which is the situation we have now before the International Criminal Court, and which has locked out thousands of victims from accessing reparations in cases where accused persons have been found not guilty. It does not take away their victimhood. It does not take away the need for the international community to respond to the needs of these victims. They are victimized. They have suffered from the serious crimes that the accused person was tried, despite the fact that he was found guilty. So tying then reparations solely to the guilt of an accused person, we need to rethink that. There needs to be a rethinking around that whole process. The UN basic principles around it, around reparations, talks about a judicial process that is tied to reparations. It does not necessarily mean that it has got to be a criminal proceeding that that is around the guilt of an accused. We need to think about other processes. They could be administrative as well, that could assist then victims to be able to make the sort of claims that perhaps Albert was talking about, that claims would be made by survivors to an administrative process and they would be able to obtain the reparations that they need.
Thank you, Alan. I will turn over to Wilfred. Wilfred, we have a question that has come through on whether this arrest of Kabuga has come a little bit too late. And we've also had questions around his age, Charles's concerns about the trial process. And earlier on, you spoke about the fact that some preparatory work had been done by the ICTR and some evidence has been preserved in the event that Kabuga was to be arrested. I just want to hear from you in terms of your estimation and these concerns that a lot of people have as to whether Kabuga, given his age and his health complications, can be successfully tried, and what is important, what are the important considerations that should be put in place as we prepare to have this trial.
Thank you, Stella. As to whether it's too little, too late, I would say that it's never too late. I think it is important that it be understood throughout the world that you cannot run from the long arm of the law. if you look at the case of Félicien Kabuga, for example, he left Chad in the year 1990, if I recall correctly. And despite that, it was possible to have, just a few years ago, a process that brought him to justice. If you look at the situation in Khmer Rouge, where there were gross human rights violations in the mid to late 70s. Again, it was not until some 10, 15 years ago that people were being brought to book. So what I would say is that it is not too little too late. Of course, there is the concern about the age of Félicien Kabuga, as to whether he would be in a position at close to 85 years to stand trial. But the thing is, other people have stood trial even at a later age. But I think for me, the most important thing, the most important message that is being sent is that international criminal justice may take time, but one day there will be the day of reckoning. And when I say the day of reckoning, I mean that Félicien Kabuga himself will have his day in court to come and explain his side of the story. Yes, of course, as I had said earlier, Rule 71B of the ICTR statute did provide for the taking of special depositions before before a judge of the chamber to preserve the evidence, and that would still be very, very useful, as I said. And it's useful that we continue having this kind of preparatory work that is done by different institutions, and that can then be clothed in validity, like the depositions that were made by the ICTR. But if you allow me, I would also want to just say something small with regard to the question of reparations. And Alan did talk about the UN principles, the principles and guidelines. In fact, as far as I understand this, impose a moral obligation on the part of states to ensure that there is a remedy, and in fact, not just a remedy, but an effective remedy, and also to ensure that there are reparations for victims of serious violations of human rights and humanitarian law. I thought I should mention that, and also perhaps at the same time, I take the opportunity to make a comment regarding the participation by Mr. Charles Adiogun Phillips. And yes, it is true that there is no question with regard to where the forum should be, because as he correctly stated, the case against Kabuga, having been the subject of warrant of arrest by the ICTR MICT, the court that would have primacy over the crimes charged would be again the MICT. Now that the ICTR is not there, but I think, and I did answer. I'm not sure I did that privately to Mr. Phillips. I would want to mention that part of this discourse is also supposed to inform the people listening in as to why here and not there, and who should be responsible for charging him. And so some of the questions, why not France, where he was arrested? That will be answered through this. Why not Rwanda, where the offenses were committed, again, that would be answered. Why or why not in a particular location and not necessarily in France, not necessarily in Rwanda, not necessarily in Tanzania, because there could be as many venues as there would be suitable for the prosecution of the case. I think the point that I want to make is that, yes, while the MICT has primacy over the offenses, over the crimes that Kabuga has been charged with, the question is still valid as to where the trial should be conducted.
Wilfred. Paul from Nairobi has sent a question for Chantal and is asking you, Chantal, what can other countries learn from how Rwanda has memorialized victims of the genocide? What can we learn from Rwanda?
Sorry, can you repeat the question?
What can other countries learn from how Rwanda has memorialized victims of the genocide?
Well, there's a lot to learn, and I think different states in Africa, but also abroad, have really taken steps to come to Rwanda to observe, to see what has happened, and the efforts that have been put in place by the government to preserve the memory and the whole history of the genocide. And so there's a lot to learn, but first of all is to have a government that we have now that really has invested a lot of time and resources to ensure that we have, for example, the genocide memorial sites at almost in every place where there are, which was the whole country where there are massacres. And this has helped not only to to have the bodies rest in a conducive environments, but also ensure that these memorial sites are not just are given the proper value and respect that they deserve, and that these are not just infrastructures that are going to be there for a short time, but the infrastructures that have their own policies on, for example, ensuring that how the remains of people that were killed during the genocide are preserved and kept in those memorial sites, for example. It also has, I think one of the other things to learn is, how the government still, but also the genocide survivors have taken steps to speak on these issues through writing, through different ways to speak on these issues, because from up until this time, 26 years later, there's still people that do not understand what really happened in Rwanda. And sometimes for me, I really experience that there can be a lot of misinformation about what happened. And I take the active role of, correcting those in misinformation in different ways, through the book I'm writing, for example, and through other interventions that I make, for example, here, to really bring light about what has happened. So I think it has been both the role of the Rwandan government, making sure that there are different efforts to ensure that this memory and the history is not taken for granted, about how the government also tries to ensure that the international community really understands and take responsibility where there is responsibility to be taken of, and then also the role of the genocide survivors themselves, which I would say for the latter is not very easy. But there's a lot of work to be done. And I would say for other countries or states, it is very important to document, it's very important to preserve in different ways. And it is very important to keep advocating with the governments, but also with the international community to really shed light on things that are going on, and not to let people but because there'll always be people with different interests that try to divert the definition or the meaning of what actually happened to people. And so it is very critical that people, but governments as well, continue investing efforts in that.
Thank you, Chantal. Alan, the issue of reparations keeps coming back. And we have a question to you from Kasiva Muli, who asks, Is there a way to ensure either through the mechanism or any other state or non-state processes that victims are fully engaged in the trial process? And if the processes of this trial, even if the process of this trial is unsuccessful, that they are enabled to advocate for reparations or any other forms of remedies for themselves?
So the biggest output for me in this entire process is the grave error that that has been occasioned, grave injustice that has been occasioned to the survivors of the genocide. They, as I said when I started, they are mere objects of proceedings, and they continue to be so, even with the residual mechanism. Unfortunately, the statutes of both the ICTR and the residual mechanism do not provide for reparation. Neither do they provide for participation of the victims. They should. Nothing stops the Security Council from making this right. Nothing stops the Security Council from creating a new process via resolution, a reparations process specifically for the survivors of the genocide against the Tutsi. It will go a long way to putting words to all the resolutions and commitments over the past 26 years as to why there should never be any other genocide anywhere, but specifically never again for Rwandans. So this would be it's a big call. I don't know whether there's political will for it. Nothing stops us from advocating for this to happen, but it is the right thing to do. There is no other process at present that could put some meat to action. I think also having the support of the African Union, certainly of the Rwandan government in this process would be key. We would need to ensure that other African states are on board, to ensure that the court, that the entity that created this court also self-corrects and sees how victims and survivors of the genocide would get some form of reparations through a fund, a trust, or a program that would be led by Rwandan survivors themselves. As to participation, it is also a very key issue. It's not provided again in the statute. This would perhaps need amendment, whether this would come via the Security Council, whether it would come via the rules of procedure and evidence of the court to allow for this to happen. We have learned so much from the participatory processes of victims at the ICC, the pitfalls that there have been, and what has also gone right. We have also learned from the extraordinary chambers in the courts of Senegal in the case against Hissène Habré, and how victims participated in that process. We know that the countries that follow a civil law tradition have always had victims participating as partie civile, and nothing stops us from doing this. And I think, you know, the Rwandan criminal justice system, again, you know, more emphasis should be put on that collaborative nature between national criminal justice systems and international tribunals. We have the false notion that international tribunals have got it all sorted out, but actually they have not. And this is one example where they have not. They have failed the very people that they say that they're working for. So national processes could come in and fill in those gaps. The Rwandan criminal justice system could come in and fill that gap and allow for a participatory regime or participatory process of survivors of the genocide. I think these are things that we need to think about going forward, but to seize the opportunity of these discussions ongoing at this time. I know that there are many other concerns in the international community. We are now plagued with the COVID-19 pandemic. International justice is falling on the back burner, but we need to, you know, pull up our socks as activists and to actually put these issues on the table, even at this time when we're threatened by many other priorities that states are placing their attention to.
Wilfred, let me come to you with this last question because you've had the opportunity to work with victims and to represent victims even at the International Criminal Court. Masharian Njoroge asks, would the international criminal justice system find ways of addressing the psychosocial impact on survivors and possibly guide on possible interventions and strategies?
Thank you, Stella. Speaking just and limiting myself to the ICC, because as Alan has already mentioned, we do not have, or under the ICTR regime, there was no room for participation by victims, first of all. And that does not mean that they were not recognized in the statute. They were recognized in the statute, but then there was no mechanism for them to participate in the proceedings. There was no mechanism for them to get reparations. But now coming to the question itself regarding the addressing of psychosocial impact on survivors, that has been done, but to a very limited extent, and particularly only to the victims who have been participating in the process, which is itself a process that requires registration. So we are not here talking about all the survivors of gross human rights atrocities. We are talking about only those people that would be recognized by the court as having been signed up as victims. And with regard to those, yes, there has been some measure of addressing their psychosocial needs, but unfortunately, the very nature of the of crimes of this nature is that there are crimes that affect far too many people for the court to be sufficiently financially resourced to be able to reach out to all the people that may be survivors. With regard to the question whether it can guide on possible intervention strategies, yes, there is actually ongoing work with regard to victims or survivors, if I may, in virtually all the situation countries that that are covered by the ICC. But then again, this still goes down to the question of, even if the psychosocial needs are addressed, in fact, if the psychological needs are addressed, there will still be the social needs that need to be addressed. There will still be the financial needs to be addressed. And very, very often, the psychosocial will not be effective if we're not adequately addressing the questions that may relate to remedies that people, survivors, may be able to see as bringing a change to their system, to their status of victimhood. And I was just trying to do the math, for example, with regard to the question of Félicien Kabuga. And I was saying, reports are that he would be worth about $20 million. Now, let's take for a moment that he has gone through the processes and then been found guilty. And I'm just saying this is really a hypothetical situation because we do not know what the evidence is either way. Now, $20 million would go around just the number of people that were killed in the genocide. That's about 1 million people. So we're talking about $20 per person. If you are now to provide reparations for the families of those killed. Of course, there are many more that survived and who would also be seeking reparations. Now, what I'm saying is that even if the entire wealth of one person who has been charged with genocide and other crimes against humanity were to be applied towards reparating survivors or victims of the atrocities, that would never be sufficient. I think that that's the point that needs to be made. And therefore, there is need to look for other solutions with regard to ensuring that there is a sense of justice that the survivor will feel, despite the fact that they may not get some compensation that can even be remotely equated to restitution.
Actually bring us to the end of this discussion. And I want to say that, I mean, what we can deduce from this conversation is that this process, while this is a great development, Kabuga's arrest and the trial that we are all waiting for and anticipate for, it remains clear that justice for survivors of the 1994 genocide in Rwanda remains incomplete as long as there are more fugitives out there who remain on the run. But also, Kabuga's arrest has brought us to a place where we have to introspect and to see how we can make this trial better. There's a lot that has been said even in the conversations that we've had that leans towards that it is clear how this, the ICTR statute or the MICT statute that will be followed for this trial has set out how the procedure should run. However, it's also an opportunity for us to ask, just because there was a way that previous trials, genocide trials, were conducted by the ICTR, can we make this process better? And in Chantal's own words, she says that while Kabuga may have been arrested and it may have brought some hope and some excitement for victims, for her personally, it's been an opportunity for her to ask, how can we make this process better for those who were affected by the genocide? And so, considering also all the attendant factors, including the age of Kabuga, his health, and all the issues that have been raised, in closure, I think we had hoped, as ICJ Kenya and Legal Action Worldwide, that we can start a conversation that helps us start a process of introspecting on how this trial in particular will be different and will have a much better and greater impact in the lives of those who are most affected by the international crimes that were committed in Rwanda during the genocide. And that said, I will hand over to Abdul, who will give us the closing remarks. Thank you.
On 11th May 1960, a team of Israeli intelligence operatives captured Adolf Eichmann in a suburb of Buenos Aires, Argentina. Eichmann was a former head of the Jewish department in the Reich Security main office and was taken to Israel to stand trial for his role in the Holocaust. He was accused of crimes against the Jewish people and against humanity. His trial opened in Jerusalem on 11th of April 1961. It proved to be a watershed moment in the post-World War II history, helping to raise global awareness on the Nazi genocide, and for the first time since the Nuremberg trials put the question of justice for the Nazi atrocities back on the world stage. The arrest and prosecution of Félicien Kabuga could do just that, bring back the question of justice for the Rwandan genocide. Since his arrest, international criminal lawyers, theorists, human rights organizations like ours have been asking and debating all the legal questions on what the right process should be going forward. We all grapple with the meaning of justice and the purpose of justice. What kind of justice is possible 26 years after the genocide? What does it take to heal a nation? When do victims get their closure? For international justice, Kabuga's arrest demonstrates that we can succeed when we have the international community's support. But all my colleagues know all too well how important it is not to transform what should be a straightforward legal procedure into a theatrical presentation fictionalized for political ends. In prosecuting Kabuga, it will not just be him at the dock, but also history. And for many people, it will be history that will be at the center of the trial. On behalf of the Legal Action Worldwide, the Secretariat and Council of ICJ Kenya, I wish to thank our panelists, Mr. Wilfred Diritri from Nairobi, Chantal in Kigali, and Alan from Pretoria. We wait to see what will unfold and believe in the words of Martin Luther King Jr. The moral arc of the universe is long, but it always bends towards justice. Thank you.